Chapter 3, Section 4. Article 1207. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with a prestation. There is a solidary liability only when obligation expressly so states, or when the law or the nature of the obligation requires solidarity. So what is solidary and joint obligation? Solidary obligation is one in which each of the debtor is liable for entire obligation, and each of the creditor is entitled to demand the satisfaction of the whole obligation from any or all of the debtors. Joint obligation is one in which each debtor is liable only for a proportionate part of the debt, and the creditor is entitled to demand only a proportionate part of the credit from each debtor. By guarantee, a person called guarantor binds himself to the creditor to fulfill the obligation of the principal debtor in the case the latter should fail to do. If a person binds himself solidarily with the principal debtor, the provisions of Section 4, Chapter 3, title of this book shall be observed. In such case, the contract is called suretyship. Suretyship is an accessory agreement by which a person binds himself for another already bound, either in whole or in part, as for his debt, default, or miscarriage. Article 1208. If from the law or the nature of the wording of the obligations to which of the preceding article refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. These are the list when personal liability of a corporate director, trustee, or officer with a corporation may so validly attached. Article 1822 and 1823. These are laws that require solidarity. Article 1824. All partners are liable solidarily with the partnership for everything chargeable under the Articles 1822 and 1823. Nature of the obligation requires solidarity. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. Joint indivisible obligation is an obligation that is not capable of partial performance. Characteristic. Number 1. All of the creditors must make a demand for the fulfillment of the obligation, otherwise the debtor or debtors may legally refuse to deliver, or he or she can insist that all of the creditors must receive the thing, otherwise he may deposit the thing by the way of consignation. Number 2. If there are two or more joint debtors, the fulfillment of the obligation requires the concurrence of all the debtors. In case of insolvency of a joint debtor, the other shall not be liable for his share. Effects of breach of joint indivisible obligation. Article 1224. If a joint debtor who failed to refuse to comply with his obligation shall bear the burden of paying all of the damages to the creditor or joint creditors, and those debtors who fulfill their promises to comply their undertaking will not contribute to the indemnity or will not join in paying the damages to the creditor. Article 1210. In case of concurrence of two or more creditors or of two or more debtors in one and the same obligation, and in the absence of express and indubitable terms characterizing the obligation as solidary, the presumption is that the obligation is only joint. Thus, the incumbent upon the party alleging that the obligation is indeed solidary in character to prove such fact with the provenance of evidence. So these are the differences of indivisibility obligation and solidarity obligation. Article 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Kinds of solidarity. These are the three types of solidarity. First, we will focus as to source. Number 1, legal solidarity. This is imposed by the law. Number 2, conventional solidarity. This is agreed upon the parties. And lastly, number 3, real solidarity. This is imposed by the nature of the obligations. Second, as to the parties bound. Under this is the active solidarity or solidarity of creditors. This means that one of the solidary creditors can demand the payment or performance of the entire obligation from the debtor of any of the debtors. The effect of this is the creation of a relationship of mutual agency among the solidary creditors by virtue of each creditor is empowered to exercise against the debtor or debtors not only the rights which corresponds to the other creditors with a consequent obligation to render an accounting of his acts to such creditors. Second is passive solidarity or solidarity of debtors. This means that an obligation is solidary for the obligors when each obligor is liable for the whole performance in such a way that a whole performance rendered by one of the obligors relieves the others of liability toward the obligee. The effect of this is that among the debtors is the liability of each debtor for the payment of the entire obligation, with a consequent right to demand reimbursement from the others for their corresponding shares once payment has been made. Lastly, mixed solidarity. This is among the debtors and all the creditors. Next is as to uniformity. Number 1, uniform solidarity. This means that the parties are bound by the same stipulation. Number 2, non-uniform or varied solidarity. This means that the parties are not subject to the same stipulations. Article 1212 in beneficial, the creditors may perform acts that will benefit each other. They may help each other to have more gains and build up their relationship in good standing. In prejudicial, one or more member performs acts that will have bad effects, loss of profit, or may harm the good standing, which the performing creditor will be liable to his co-creditor. Article 1213. A solidary creditor cannot assign his rights without the consent of others. This is a general rule, but the exceptional is that the assignment is allowed if it is the consent of all the other solidarity creditors. Article 1214. When one creditor makes a judicial demand for payment, the tacit representation of other creditor is considered revoked. During the pendency of action, the creditors who did not sue lost their representation of others.
Article 1215. Novation, compensation, confusion, or remission of the debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation, without prejudice to the provisions of article. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for the share in the obligations corresponding to them. Novation. A novation is an agreement made between two contracting parties to allow for the substitution of a new party for an existing one. Novation is a mode of extinguishing an obligation. Example: B and C solidarily owe X and Y the amount of 100,000 pesos. B and C agreed with X only that instead of paying the amount of 100,000, B and C will just deliver a specific car. Upon delivery by B and C of the specific car to X, their obligation is extinguished. Nonetheless, X is liable for the share of Y in the amount of 50,000. Compensation. Compensation shall take place when two persons in their own right are creditors and debtors of each other. For example, B and C solidarily owe X and Y the amount of 100,000. Prior to this agreement, X was already indebted to B for 100,000 because of a separate contract. If X and B agreed to a compensation or set-off, then the obligation is extinguished. However, X is liable to Y in the amount of 50,000, as this is his share in the obligation. Also, C may pay B's share in the amount of 50,000. Hi, good day. So in the continuation of Ms. Gialon's report regarding the modes of extinguishing an obligation, I will be explaining to you the confusion or merger of rights. So there are 4 modes of extinguishing an obligation, mainly novation, compensation, confusion, and remission. So in confusion or merger of rights, the obligation is extinguished from the time the characters of the creditor and debtor are merged in the same person. So it means that it is absurd for a debtor to be his own creditor, since a person cannot claim payment from himself. So as an example, B and C, solidary debtors, owe solidary creditors X and Y the amount of 100,000 as evidenced by a negotiable promissory note. X and Y negotiated this promissory note to H, then the latter negotiated it to I, then to J, then to K, then to L, then back to B only. The obligation is then extinguished. Nevertheless, C is liable to B for his share in the amount of 50,000 pesos. So in the example, B and C solidarity debtors na ay utang ni X and Y, the solidary creditors, through a negotiable promissory note in the amount of 100,000. So X and Y negotiated it to H, then adto ni I, then sunod ni J, then adto ni K, and then to L, and then back to B only. Now, B becomes the creditor. So diba, tungod sa negotiable promissory note, he was the debtor then, karon si na ang creditor in favor of L. However, still, C is liable to B for his share in the amount of 50,000, since sila man ang solidarity debtors ni B in the amount of 100,000. But then again, si B ra ang creditor ni L, since si Jara man ang negotiatan. So therefore, it is just but right that D should pay B his share of 50,000. Now let's proceed to remission or condonation. Remission is an act of liberality by virtue of which the obligee, without receiving any price or equivalent, renounces the enforcement of the obligation, as a result of which it is extinguished in its entirety or in that part or aspect of the same to which the remission refers. Condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. As an example, B and C, solidary debtors, owe X and Y the amount of 100,000 pesos. Before the debt matures, X condoned or remitted the obligation in favor of B. In this case, the obligation of B and C are extinguished because of condonation or remission. Now, if the remission is without the knowledge or consent of Y, X is liable to Y in the amount of 50,000. Moreover, C is not liable to B for his share because of the principle, the remission of one is the remission of all. Now let's proceed to Article 1216. The creditor may proceed against any one of the solidary debtors, or some, or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. So, maaaring habulin ng creditor ang sino man sa mga solidary debtors, ilan sa kanila or kahit lahat sila ng sabay-sabay. Ang paghabol sa isa sa kanila ay hindi hadlang sa paghabol sa iba hanggat hindi nasa sa katuparan ang lahat ng obligasyon. Example, X, Y, and Z solidarily oblige themselves to pay 450,000 to B. B may collect from either X or Y or Z, or X and Y, or Y and Z, or X and Z, or from all of them simultaneously, the total amount of 450,000, and the obligation will be extinguished. Nonetheless, if there is partial payment from any of them, the remaining balance can be collected from the others. So X, Y, and Z are obliged to pay 450,000 at ni B. Obviously, X, Y, and Z are the debtors and B is the creditor. B may collect the total amount of 450,000 either ni X, ni Y, or ni Z, or B may also collect it either ni X and Y, Y and Z, Z and X, or bisan kinsa nila since sila may naay utang ni Ja. The moment na ma-receive ni Ja ang total owed money, the obligation will then be extinguished. Now, if si B adto na ningil ni X and Y and partial lang ilahang nabayad, ang remaining balance should be paid by Z. Note that, indeed, Article 1216 of the Civil Code provides that a creditor may sue any of the solidary debtors. Effect of demand against one of the solidary debtors. So in the effect of demand against one of the solidary debtors, the demand made by a solidary creditor or creditors against one of the solidary debtors shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. So, since the liability is solidary, the other solidary debtors are not indispensable parties in a suit filed by the creditor. The bringing of an action against a solidary debtor to enforce the payment of the obligation is not consistent with and does not preclude the bringing of another to compel the others to fulfill their obligations. And in case of death of one of the solidary debtors, the creditor may proceed against the estate of the deceased solidary debtor alone, or against any or all of the surviving debtors whose liability is independent and separate from the deceased debtor, instead of instituting a proceeding for the settlement of the estate of the deceased debtor wherein his claim could be filed. Article 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. So, ang pagbabayad na ginawa ng isa sa mga solidary debtors ay magwawakas ng obligasyon. Kung ang dalawa o higit pang mga solidary debtor ay mag-alok upang magbayad, ang nagpapautang ang maaaring pumili kung aling alok ang tatanggapin. Now, he who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. Siya na nagbayad ay maaari lamang humingi mula sa mga kapwa niyang nangutang ng bahaging tumutugma sa bawat isa, kasama ang interes sa kabayarang naibigay. Kung ang kabayaran ay binigay bago ang takdang araw ng pagbabayad ng utang, walang interes na maaaring mahingi para sa panahong lumipas. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Kapag ang isa sa mga solidary debtor, dahil sa kawalan niya ng kakayahang magbayad ng utang, ay hindi makakapagbabalik ng kanyang bahagi sa nagbayad ng utang, ang kanyang bahagi ay dapat batahin ng lahat ng kapwa niyang nangutang sang-ayon sa bahagi ng utang ng bawat isa. Effect of payment by a solidary debtor. Payment, in which means not only the delivery of money, but also the performance, in any other manner, of the obligation, is the operative fact which will entitle either of the solidary debtors to seek reimbursement for the share which corresponds to each of the debtors. Payment by one of the solidary debtor extinguishes the obligation. For example, X and Y and Z solidarily obliged themselves to pay 450,000 to B on December 31, 2018. If Z offered to pay and thereafter paid the 450,000, the obligation is extinguished, and Z can thereafter ask for reimbursement from X and Y their share in the obligation, which is 150,000 pesos each. Now, what if sa day sa due date, si X and Y ni offer na bayaran ang entire amount sa obligation? Then B, the creditor can choose which offer to accept, either kang X or Y. Kung kinsa man nila iyahang pilion, then the obligation between the creditor and the debtor will be extinguished. Now, what if nibayad si X daan sa total amount on December 31, 2018? Then again, the obligation is extinguished. Consequently, X can demand the share of Y and Z in the amount of 150,000 kada usa nila. X cannot demand for interest since ang obligation na bayaran man before it's due. But he can demand 3 months interest if he paid on December 31, 2018, and thereafter, Y and Z reimbursed him on March 31, 2019. What is suretyship contract? Suretyship contract, by definition, refers to an agreement where under one person, the surety, engages to be answerable for the debt, default, or miscarriage of another, known as the principal. So, suretyship is merely an accessory or a collateral to a principal obligation. Although a surety contract is secondary to the principal obligation, the liability of the surety is direct, primary, and absolute, or equivalent to that of a regular party to the undertaking. A surety becomes liable to the debt and duty of the principal obligor even without possessing a direct or personal interest in the obligations constituted by the latter. A surety is considered in law to be on the same footing as the principal debtor in relation to whatever is adjudged against the latter. The term surety has a specific meaning under our Civil Code. Article 2047 provides the statutory definition of a surety agreement thus. Article 2047. By guarantee, a person, called the guarantor, binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. If a person binds himself solidarily with the principal debtor, the provisions of Section 4, Chapter 3, Title 1 of this book shall be observed. In such case, the contract is called a suretyship. Solidarity and surety distinguished. Now the two are similar in the following ways. A solidary debtor, like a surety, stands for some other person. And both debtor and surety, after payment, may require that they be reimbursed. The difference is that the lender cannot go after the surety right away. There has to be default on the part of the principal debtor before the surety becomes liable. If it were mere solidarity among debtors, the creditor can go after any of the solidary debtors on due date. Article 1218. So in Article 1218, payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. For an example, A and B are solidarily bound to give C some drugs worth 1 million pesos. Later, the law prohibits the transaction of the said drugs and declares the drug to be outside the commerce of man. Knowing this, A nevertheless delivers the drugs to C. So may A now get reimbursement from B? The answer is no. A cannot get reimbursement from B since A made the payment after the obligation had become illegal. Article 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors. In case the debt had been totally paid by any one of them before the remission has effected. So, ang pagpapatawad ng creditor sa bahagi ng isa sa mga solidary debtors ay hindi mapapawalang bisa sa responsibilidad ng pinatawad sa kanyang mga kapwa debtors kung ang obligasyon ay maisakatuparan na ng ibang mga debtors bago pa man ang pagpapatawad. Payment is a mode of extinguishing an obligation. Hence, upon full payment, the obligation is already extinguished. Consequently, the remission effected after full payment is of no effect as there is nothing more to remit. For example, X and Y solidarily oblige themselves to pay B and C the amount of 150,000 pesos. Later, B remitted or condoned only the share of X, which is 75,000 pesos. Unknown to X, the whole obligation was already paid by Y to C before the remission took place. So in this case, X is still liable to Y because the obligation was extinguished first by payment before the condonation set in. And take note that both payment and condonation are modes of extinguishing an obligation. It's only that payment in this case precedes the condonation. Article 1220. The remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. So, ang pagpapatawad sa buong pagkakautang ay nakuha sa pamamagitan ng isa sa mga magkakasamang mangungutang. Wala siyang karapatang manghingi sa kapwa niyang mangungutang. There is nothing to be reimbursed because he did not spend any money, the remission being a gratuitous act. Example: X and Y solidarily obliged themselves to pay B the amount of 300,000 on December 31, 2018. Because of their present financial condition, X pleaded with B for the latter to extinguish the obligation. Consequently, B condoned the obligation. Now X is demanding from Y the amount of 150,000 because he alleged that it was through his effort that B condoned the obligation. Now, is X correct? The answer is no, because the remission of the obligation obtained by him does not entitle him to reimbursement. Take note that the principle of solidary obligation is all for one and one for all. Hence, the remission of one is the remission of all. Article 1221. If the thing has been lost, or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor for the price and the payment of damages and interest without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraphs shall apply. So, in case of loss of the thing or the impossibility of the prestation, the following rules apply. First, if there is no fault on the part of the solidary debtors, the obligation is extinguished. Second, if there is fault on the part of any one of them, all will be liable without prejudice to their action against the guilty solidary debtor. And the third, if the loss or impossibility of performance is due to fortuitous event, there is no liability unless there is delay, in which case all will be liable without prejudice to their right to go against the guilty or negligent solidary debtor. For example, X and Y oblige themselves solidarily to deliver a specific washing machine to B and Z. Subsequently, the said washing machine was lost by fortuitous event. So therefore, the obligation is extinguished. Rule in case the thing has been lost or if the prestation has become impossible through the fault of one of the solidary debtors. All of the solidary debtors shall be liable to the creditor for the price and the payment of damages and interest. However, this is without prejudice to their action against the guilty or negligent debtor. Same goes in the rule in case the thing has been lost or if the performance has become impossible through fortuitous event, but after one of the solidary debtors has incurred legal delay. Article 1222. A solidary debtor may, in actions filed by the creditor, avail himself of all the defenses which are derived from the nature of obligation and of those which are personal to him or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of that for which the latter are responsible. Defenses available to a solidary debtor. First, defenses derived from the nature of the obligation. So this is a total defense. Thus, all the solidary co-debtors are benefited. Examples are payment or performance, lack of cause or consideration, condonation, prescription, and in cases of absolutely simulated contract. Second, defenses which are personal to him or pertain to his own share. This constitutes total defense and partial defense. Examples of the former are minority, insanity, fraud, mistake, violence, and intimidation, while examples for the latter are non-fulfillment of a suspensive condition and non-arrival of a suspensive period. For example, in a contract, X and Y are the solidary debtors of B in the amount of 10,000 pesos. When B made a demand from X, the latter raised his defense of insanity at the time of the perfection of the contract. Now, if this is true, X is not liable. As to X, this is a complete defense. Third, defenses which are personal to other solidary co-debtors. A solidary debtor may avail himself only as regards that part of the debt for which the other solidary co-debtors are responsible. Example: in a contract, X and Y are the solidary debtors of B in the amount of 10,000. When B made a demand from Y, the latter raised his defense of insanity of X at the time of the perfection of the contract. Now, if this is true, then Y is liable only for 5,000 pesos, his share in the obligation. As to Y, this is a partial defense. Hence, he is not liable for the share of X amounting to 5,000. This ends my part of our report regarding Chapter 3, Section 4, Joint and Solidary Obligation. Section 5 of the said Chapter 3 of our Civil Code will then be explained by the next reporters. That would be all. Thank you for your time and effort.